Bremner.
Good morning, my lady. Yesterday afternoon I had just been about to deal with Milano Friends' reliance on AB and the Ministry of Defence.
Yes.
I don't intend to take up very much time at all in relation to that case, but if the court does want to see it, it's in the Authorities Volume 4, tab 30, and it's page 1431. Now, Milano Friend referred to this case as being one where limitation ran when, as he put it, the claimant had no way of knowing they were going to win. That was on day one. And my simple point in relation to AB is that the revenue in this case is ignoring the context in which AB was decided, and AB in fact doesn't assist this court in the particular inquiry with which we're concerned. The court will recall, and one can see this, it's paragraph 25 in Lord Wilson's judgment, 1452. The claimants reasonably believed that their injury was attributable to the nuclear tests, that's by the letter E on 1452, and they issued proceedings on that basis. Their problem was an evidential one. They couldn't prove causation on the balance of probabilities. It's discussed in various places, but one can see it just above the letter G in that same paragraph 25. But their trouble, of course, and this one sees if one goes back to paragraph 3 in Lord Wilson's speech, 1443, but over into 1444, it's a legal impossibility for them to have lacked knowledge after having issued. That's by the letter B. And so the point in AB, and this is what one gets out of paragraph 25, at the end of 25, is that the lack of evidence in that case was held to be irrelevant to the inquiry under sections 11 sub 4 and 14 sub 1. So what AB shows is simply that the belief has to be reasonably held. It doesn't have to be justified on the basis of evidence. That's what divided the majority and the minority in the court in that case. That's not this case. We are looking at a prior stage in the analysis. We're asking when, exercising reasonable diligence, a claimant could have formed the view that there was a real possibility that these tax payments had been made by mistake. And that's a different question to what was at issue in AB, and the analysis, in my respectful submission, doesn't actually help in working out whether Mr. Justice Richards got it right or not. So that's what I would say about AB. And that finishes my submission on the first aspect of Milano Friends' Ground 1. The second aspect of Ground 1 was a complaint about the judge's language. And it was said in writing that he employed the language of would rather than could throughout the judgment, and there were a few echoes of that orally. I simply say that that misunderstands the nature of the inquiry that has to be made. The court's looking at what could be discovered by the claimant through the exercise of reasonable diligence. So, on the judge's findings, a claimant exercising reasonable diligence would have consulted an appropriate advisor, and indeed that's required essentially by the assumption that needs to be made. So that's the step that the exercise of reasonable diligence required. If you then ask, well, what could have been found out by the claimant exercising reasonable diligence, what could have been found out is what such an advisor would have told them. And that's the process of analysis that one sees in the judgment, for example, paragraphs 29 Roman 3 and Roman 4. And that approach in my submission is a perfectly conventional one, looking at what an investigation would reveal. One can see, for example, in this court's judgment in OT Computers. It's also in volume 4 as it happens. It's behind tab 33. It's paragraph 47 of the judgment of Lord Justice Males. I don't particularly need the court to go to it. It's simply that the observation there is made, and it's a concealment case. It's not a mistake case, but the claimant is held to be taken to know those things which a reasonably diligent investigation would then reveal. So there's nothing odd or eccentric about what the judge did in this case. Some of it, of course, is affected by the nature of the point at issue, and we know, depending on the nature of the point at issue, the claimant may need to take advice in order to work out whether there is a real possibility that a mistake has been made. Indeed, I think my learned friend accepted that on day one when he said you need some advice that there's a real possibility you've made a mistake of law. So there's nothing in the would-could complaint. The third aspect to ground one, at least in writing, was a complaint that the judge presented the question as being a search for the date of constructive discovery. Wasn't developed orally, and quite rightly not. The complaint in writing seemed to be, it's paragraph 46 of my learned friend's skeleton, seemed to be that by using the language of constructive discovery, that showed the judge must have applied some different test to the one he should have applied. The problem with my learned friend's argument, and the reason why he was right not to develop this orally, is that the language of constructive discovery is a defined term. In the judgment, the judge tells us what he means by constructive discovery, and it's paragraph 18. He says he's focusing on the principles to be applied. So it's 496 in the core bundle. He's focusing on the principles to be applied and deciding the point at which the claimants could, with reasonable diligence, have discovered their mistake, to which I will refer as the question of when there was a constructive discovery. And that was absolutely correct. He was also clear, and this was 21 Romans 6, that the question was not whether the mistake should have been discovered earlier. So constructive discovery, given the definition, it's perfectly sensible and appropriate shorthand. As it happens, I don't need the court to go back to this, you'll see very similar language used by the Supreme Court in Supreme Court 2. There are examples in paragraphs 194, 195 and 236 of the court referring to what the claimant knew actually or constructively. And then the last aspect of ground one was a complaint about the burden of proof. Short answer to that is that the judge directed himself in terms that the burden was on the claimants. That's paragraph 21, Roman 2. And he returned to that, among other places, at paragraph 117. And he reiterated there that he was asking, page 519 in the core bundle, whether the claimants can discharge their burden of proving there was no such constructive discovery before 6 June 2000. And his conclusion is that that burden was discharged. That's paragraph 129. So one simply can't say that he failed to give proper weight to the burden of proof. He directed himself appropriately, and then he applied that direction. Just for completeness in relation to the test, my friend mentioned an article by Dr. Bessick on day one. He said it's there at the back of the bundle. Didn't actually make any submissions about it. We didn't open the article. I'd simply respectfully suggest that an article written just a few months ago is not going to help very much in terms of the analysis of legal thinking at the relevant time. There's quite a lot one could say about the particular criticisms of Dr. Bessick, but seeing as no submissions have been made about it, I wasn't going to take up time in responding to points that haven't been made. So that was ground one and the test. Ground two is to deal with the points that my friend made about the appropriate advisor concept. And on the scope of ground two in the oral submissions, it does appear that the revenue is seeking to expand the grounds, because, and this was canvassed in the exchanges with my friend, if one looks at ground two, just page 17 in the core bundle, On the face of it, it doesn't challenge the use in the first place of the notion of an appropriate advisor, but certainly at times in his submissions, my friends seem to be saying it's not relevant, or you shouldn't be looking at this. That isn't covered by the grounds of appeal, but in any event, the criticism is misplaced, both as to the principle and also as to the more detailed points in relation to the appropriate advisor.
There's no doubt we were told on a number of occasions that the court could just do it, and indeed should just do it for itself.
Yes.
And there were some exchanges, amongst others, pointing out that if that was the case, then the Supreme Court could, and
indeed,
some would say respectfully, should have done it for themselves. But what are you actually saying? What's your response on that?
Well, I'm saying that the appropriate advisor approach, that is a perfectly valid application of the test set by the Supreme Court.
Because the Supreme Court, I think this goes wider than simply the characteristics or otherwise of an appropriate advisor, and whether he's an appropriate hypothetical person to introduce to the panoply of hypothetical people that the law knows. I mean, I don't think I've misunderstood the submission that was made. I mean, the submission that was made is that actually the whole exercise of asking, what was the legal understanding in the profession or otherwise at the time is just misconceived.
Well, that was my understanding of what's being said. I take it in two stages. It goes beyond the grounds of appeal for which permission's been given, but it's wrong anyway, because what the Supreme Court has directed, and if one looks particularly at paragraphs 178, 209, 210, 211, 255, we've seen them, I'm not going to take you back through them. What is being directed is an inquiry into actual legal thinking, and an inquiry that is to happen by means of evidence. And it would make no sense at all in my submission for that inquiry having been done, for the court to have said, well, it's very interesting, we've got these expert reports, but actually we're just going to do this ourselves. It doesn't matter what the experts say. And it isn't right in my submission for Melanchthon now to come to this court. I did make the point in the skeleton, the revenue themselves said in their written closing that the court should ask the counterfactual of what advice would have been given. And the way they sought to approach that was through Professor Barnard's evidence. That factual case failed. It was rejected by the judge, who preferred her evidence to that of Mr. Gammy. And it sits very ill for Melanchthon now to come to this, but it doesn't it?
Other way around.
I'm sorry, who preferred Mr. Gammy's evidence. I'm so sorry, preferred Mr. Gammy's evidence to the evidence of Professor Barnard. And it sits very ill for Melanchthon to say, well, I failed on the expert evidence, however, this was all irrelevant anyway. And it sits very ill with the procedural history of Mrs. Justice Fart, by agreement, directing the question to be asked and for that exercise to be being done. One can't say that exercise is irrelevant and the court just does it for itself. It's an evaluative exercise into what actual legal thinking was at the time. That's my answer to my Lord Justice Snowden's question. One is hypothesizing a well-advised multinational. So this is a multinational who can get advice. And part of that exercise, particularly in circumstances where Melanchthon was disputing, one important part of his case below, so where you would just ask an EU lawyer, was to say, well, what would such an advisor know? And what would their expertise be? That's a perfectly sensible and normal application of the inquiry that's being directed. So in terms of the point of principle, should this be being done at all? Yes, absolutely it should, is my respectful response to the submission. There were also some more specific criticisms that Melanchthon made. One of them, which he did pursue orally, was a criticism of the finding in paragraph 32 of the judgment, when the judge noted that the appropriate advisor would be guided by what the judge described as a high-level appreciation of relevant legal principles. And he went on to say that his focus would be on core knowledge rather than more recondite matters that could be ascertained only following detailed analysis or investigation. A couple of points on this. That, first of all, the judge is making the obvious point that, and he says this in the second sentence of paragraph 32, that the well-advised multinational exercising reasonable diligence would have nothing like the quality or quantity of material available to it that had been set out in the experts' reports. That's the context of that observation. And the second point is that we know that the advice we're talking about is advice that's been given before we get into the preliminaries to litigation, because if we're at that stage, then time is running. So we're looking at whether such advice that would have been given would have been sufficient for the claimant to have sufficient confidence to embark on those preliminaries. And it is slightly more complicated in the context of a mistake of law, because the preliminaries include getting advice in relation to the claim, expressly so. But it's the prior stage that we're dealing with here, and that's why the judge in my submission is absolutely right when he notes that the constructive discovery inquiry, it's a prelude to further analysis that must be performed. The third point, and I'll deal with this in more detail under ground 4, is that the judge did address, perfectly appropriately, all of the cases that my learned friend relied on. This was at about 2:15 yesterday, so Avoir Fiscal, Daily Mail, Schumacher, Commerzbank, they were the ones identified. As we'll see, they're all addressed, and perfectly correctly so. Fourth, and in any event, what Mr. Gammy's evidence demonstrated, and I'll make this good in relation to ground 3, is that there was the professional consensus summarised at paragraph 71 of the judgment. And so the evidence was, that's the view that's going to come back from the appropriate advisor. In a sense, it doesn't really matter what approach the appropriate advisor takes, whether it's a more broad brush approach or a really down in the detail approach, because we know from Mr. Gammy what the ultimate expression of the consensus would be. And then a slight side point on this, but I think relevant under this ground. There was criticism orally of paragraph 87 of the judgment. This is, if you like, the significance of EU expertise as against tax expertise. It's at 86 and 87 is learned friend's submission, that there was a fixed mindset among tax professionals. And you've got to look beyond that, and an EU lawyer would have seen this either immediately or much earlier, or something of that sort. And the judge says at 87, well, you need to establish comparability, and he's absolutely right about that. And he then says, so even if the well-advised multinational goes to the kind of EU law generalist that the revenue were invoking, that person would still need, or such a person would still need to look at the comparability question. And to answer that, you need to discuss the matter with advisors with expertise in the detail of the UK tax regime, and that would engage the consensus. And Blairfriend tries to get round that by saying that this is somehow the EU specialist blindly accepting the implication of what was being said, the position of the tax law. And that's a bad point, because in a case like this, comparability, that's going to be determined by the national tax provisions. An EU lawyer simply isn't able to work this out without engaging with the tax provisions. Just to develop that a little bit, we saw in Avoir Fiscal, for example, that comparability was established because both French companies on the one hand and French branches of foreign companies on the other, they were both taxed in the same way on their income. So there's no material difference in the position under French law. That was why the Court of Justice said there was comparability. The position in the UK system was very different indeed. Take the ACT system. the income there in the UK, it had been subject to ACT, the resident income. Non-resident income had not been. And then for D5, the foreign dividend income had been subject to overseas tax, not to UK tax. And Mr. Gammy explains in his report that was seen as a difference that would have negatived comparability. So you have to analyse the comparability question, taking into account the tax position. It's inescapable. So there's nothing in ground 2 in the appropriate advisor, either at the general level or in relation to the more specific criticisms. What Maloney then sought to do, and he developed this orally, was develop his ground 3, which was looking at what did Mr. Gammy's evidence actually establish. Can I make 5 points on this? First of all, in terms of Mr. Gammy's approach, we know that Mr. Gammy was instructed to answer the question set in the order made by Mrs. Justice Falk, as she was. That's paragraph 5 of Mr. Gammy's report. That's what he did. And the judge was fully entitled, having read the report and listened to the cross-examination, to conclude that that was setting out a consensus. It wasn't just Mr. Gammy's own view or something that he was projecting onto other people. And indeed, there are numerous examples within the report, and indeed we saw some more in the oral evidence that Learner Friend took the court to yesterday, and I don't want to go through all of that again. But Mr. Gammy makes it absolutely clear that he's talking not just about his own view, he's talking about his understanding of the general view. And there are examples in the report, in paragraph 68 on page 111, of the unagreed bundle is one of them. It's not very profitable to take the court through all of those. You can see what it is that he's doing, but in any event, it was a matter for the judge.
When he's talking about general view, was that the general view in the UK, or was it just...
So,
when you summarise Mr. Gammy's evidence as talking about the general view, can I just pick up, what do you mean, the general view? General view amongst whom? I mean, Mrs. Justice Falk's order, which was a consent order, I think was jurisdiction neutral, wasn't it?
Yes, that's right.
It simply talked about... I can't remember exactly words, but it's something like the understanding.
Development of legal thinking in relation to the question of.
Right, and it didn't pin it to any particular jurisdiction or group of people or otherwise.
No, that's right.
So,
that's right, Lord. A couple of points. First of all, we're dealing with a UK-based multinational. One would expect this to be focused on UK legal thinking rather than a requirement to go and dip into what's going on in other jurisdictions, point one. Point two, Mr. Gammy...
This is to do with cross-border dividends, and so why wouldn't a UK corporation properly advised, or their initial advisor, twig that there might be other jurisdictional issues involved?
No, because you're actually asking me a different question with respect, which is that you might have to look at other jurisdictions for the learning. You'd have to know that legal thinking might be more ahead. There might be something else in another jurisdiction, and that there's something to look at. There's no reason to think that reasonable diligence would involve expanding the search to other countries, point one. But point two, this doesn't actually matter, because Mr. Gammy had also looked at where he could, beyond the UK. He had spent time in Holland in 1998. He'd been the Unilever professor of, I forget exactly, of international tax, I think it was, at Leiden. And he does comment and it's paragraph 124, I think, in his report. If you just give me one moment. So this is someone who is extremely learned in UK tax law, in European law, but also in laws relating to other systems, as you can see from his report. It's page 127 in that additional bundle, and I think it's within volume 1 of the unagreed bundle, but he says that he thinks it would be fair.
Hang on. Sorry, if you're going to give us a reference, give us a second to get there.
I'm so sorry, Lord. It's volume 1, tab 7, and it's paragraph 124 of Mr. Gammy. And just to summarise, he's making 2 points. His experience is that legal thinking in terms of the potential impact of EU law in general was well ahead, but notwithstanding that, he says, I've not detected in my papers or in the literature of the time any specific suggestion that the ECJ might eventually decide that this is a breach of the treaty. And if one looks, there's the very long index in the supplementary bundle, which I don't call it to go through. It's the index to what was called the expert materials bundle. It starts at page 157 in that supplementary bundle. That is a vast array of literature. It's articles, book chapters, all sorts of things, not including any of the judgments. It was 7,700 pages plus long. There's been an exhaustive trawl of the material. And it's not an answer to say, well, Mr. Gammy's somehow focused on the UK to the exclusion of other things. Well, this could have been thought of. Mr. Anderson, I hoped I made it clear, if I haven't, that the material within the 7,700 pages includes Europe-wide material and indeed lots of foreign material. There's been an exhaustive inquiry into this. Just to give the court an example, I hadn't wanted to go to the detail, but I think maybe I need to in light of the question. Paragraph 71 in Mr. Gammy's report, which is in page 111 of volume 1 of the unagreed documents. He describes there...
Page or paragraph?
Page 111, it's paragraph 71.
Thanks.
He describes there a conference that the IFS held. It's attended by, among other people, representatives of the Commission. And that's one of the episodes he describes where this point simply didn't come up. And one also looks, and I'll show the court a little later, a couple of references to the Ruding report. That's an incredibly high-powered collection of practitioners, academics, etc., Europe-wide, and they don't identify the point either. So it's simply not right to say this was somehow wrongly focused on the UK. How do we know that somewhere elsewhere in Europe wasn't thinking of this? Had there been serious legal thinking on this that might have supported or suggested that such a claim was viable, there can't be any doubt it would have been found. This test has to be applied in a practical and realistic way. And Mr. Gammy has actually, he's done the job. The other point, I don't think I'm going to need Mr. Gammy's report again for a while. The other point to deal with is the reliance my learned friend placed on the absence of contemporaneous material. The court will recall it was said, well, it's a funny sort of consensus that it wasn't written down, essentially. The first point to make on that is that the judge was well aware, going back to the judgment, that the full extent of the consensus wasn't set out in the contemporaneous material. He says that in paragraph 81, core bundle, page 511. And he's dealing there expressly with the submission that the revenue made, that the consensus was unevidenced. That's recorded at paragraph 79. And he rejects that in paragraph 80, having noted that the absence of contemporaneous material, it's a relevant consideration. So he took it into account. And he says, quite rightly, it could be one of two things. It could be that the consensus was so firm it didn't need documenting, or that there was no consensus at all. And his conclusion, having read and heard Mr. Gammy's evidence, was that the consensus was operative despite not being documented, paragraph 80. And the judge was perfectly entitled in my submission to weigh up the competing expert evidence, consider the documentary evidence, and to conclude as he did. The judge was also right, but I think learned from Mr. Aaronson's already dealt with this point, that the judge was right that the Farmer and Lyle passage, that was at the very least an allusion to the consensus. I wasn't going to repeat all of that, but that point is relevant to this submission as well. And then also under this heading, my friend tried to get something out of the Schumacher case. Said it had caught the attention of advisors, and that was significant. And a similar point was made regarding the commencement of the Hearst litigation. So if I may just now, I'm just going to deal with the reliance that was placed on Schumacher and on Hearst. Dealing with the judgment first, paragraph 64, the judge notes, page 507, that this would have been of real interest to the appropriate advisor, and he notes what Mr. Gammy said about it being a sort of invitation to probe the extent to which member states truly were exercising their competence consistently with the treaty. And he says at 65 that Hearst is an example of that invitation being taken up. But what he concludes, and this is 71 sub 4, is that while Schumacher and the bringing of the Hearst claims, they caught attention, legal thinking hadn't yet re-evaluated the propositions that he sets out in 71.1 to 3. And he explains the reasons for that conclusion carefully and in some detail in 93 to 101. And in 93, the judge reiterates Mr. Gammy's observation about the invitation to consider EU law points. But what he says in 94 is that those points don't cause him to doubt Mr. Gammey's opinion. And he highlights two points in 94. First, that although Schumacher comes to be cited often later, the full implications of the proposition for which it's cited, that member states must exercise their competence consistently with community law, those full implications weren't appreciated by July 96, the time he's focusing on at this point. And the second point he makes, and he's absolutely right about this, is that the facts of Schumacher were stark. Just pausing on that.
What's his basis for the first proposition before you get on to the second one?
And what we'll see is the basis for that is Mr. Gammey's evidence, and I'll show you where Mr. Gammey dealt with that. Mr. Gammey's evidence shows that essentially what the judge found. But can I just complete what I was going to say on Schumacher before dealing with what Mr. Gammey said? The point in Schumacher was that you had a Belgian national living in Belgium with his family, but he earned no significant income in Belgium, and instead he derived all his income from employment in Germany. And it's that feature that, in the eyes of the court, made his situation comparable with that of a resident, because to all intents and purposes, actually, from the perspective of the tax system, he may as well have been German resident. That's why Schumacher is an exception to the general proposition that the Court of Justice identifies in paragraph 31 of its judgment, that normally a resident and a non-resident are not in a comparable position. In terms of Mr. Gammey, I show the court two passages in particular in relation to this. So this is in the unagreed supplementary bundle, volume 1, tab 7. And it's particularly paragraph 119, page 126. It's his observation that the invitation is tempered by the court's reaffirmation of the principle that in relation to direct taxes, situations of residents and non-residents are not, as a rule, comparable. And having gone through some more details in relation to Herx, Mr. Gammey then has a section headed up Taking Stock at the end of 95. So this is after Schumacher, top of page 127. And he makes the numbers. I'm so sorry, lady.
Sorry, I missed the reference.
I'm so sorry, it's the top of page 127.
Yes. Oh, yes.
Taking Stock at the end of 1995. And he makes various points that are relevant primarily to the Herx litigation. One sees that, for example, in paragraph 127. But as he observes in 129, none of that affected the surplus ACT or FID issues. That's the top of paragraph 129, also at the top of page 129. And it's a point he elaborates on in 131. The final sentence of that, this is part of his stock take. He thinks that the suggestion community law required domestic and international situations to be accorded the same treatment would have been thought to go well beyond the scope of the ECJ's powers and to undermine entirely member states' competence in the sphere of direct taxation. And he then goes on after that to deal with 96 to 2006. That's why I say the judge's conclusion in relation to what Schumacher did is amply justified by Mr. Gammey's evidence. In relation to Hurst and the bringing of the Hurst proceedings, the judge deals with that at paragraph 96 of the judgment and following. And there he accepts Mr. Gammey's evidence that in July 1995, a D5 claim or an FII claim, on the one hand, that would have been perceived as a very different challenge to the ability to make the group income election. And he gives a clear reason for that. The point in Hurst was that it was being said that the UK subsidiary paying the dividend to the non-resident parent, that was in a comparable position to the UK company paying the dividend to the UK parent. And critically, there's no attempt and no need to say that the UK has to forgo charging ACT or to give tax credit. That claim didn't raise any question touching on double taxation or the UK having to give up its taxing rights. The judge says rightly that this is very different from the D5 claims and the FII claims. And that conclusion, it reflects Mr. Gammey's expert evidence, is particularly paragraphs 51F, which we looked at with the learned friend, which is part of the executive summary, and the points reiterated by Mr. Gammey in his paragraph 127, where he repeats the same point in some more detail, which is page 128 in the unagreed bundle. And nothing in the article that Mr. Gammey wrote at the time with Mr. Branham undermines that. Mr. Gammey was asked about the article that he'd written, and he was very clear that the Hurst claim, that was dealing with a different situation. Indeed, there's no suggestion in any of the contemporaneous literature that the bringing of the Hurst litigation might suggest that D5 claims or FII claims are even a possibility. The one other point I should probably pick up at this point is the reliance my learned friend placed upon Wheelocks. 2 points on that. There was no cross-examination below of Mr. Gammey in relation to Wheelocks. And actually, the reason for that is Wheelocks is just not relevant to this issue. Wheelocks is a case where, and we saw this with my learned friend yesterday, in Wheelocks, like Schumacher, the non-resident taxpayer, he was resident in Belgium, he received all his income from a Netherlands business. That's paragraph 10 of the judgment. It's page 1936 in the authorities. That's why comparability was established. And just like in Schumacher, paragraphs 17 to 18 in Wheelocks reiterate that usually residents and non-residents are not in a comparable situation. So Wheelocks adds nothing to my learned friend's case. The final point on ground 3 is to address the complaints that my learned friend made about how the consensus came to be dismantled. Because it's said that what the judge found as to the dismantling of the consensus, it wasn't rationally supportable. Now, in my submission, the judge was absolutely right to recognise that Foucault was a critical development. It was a very significant case. The only respect in which the judge went wrong, and we'll see this under the cross appeal, is that he thought that Foucault had taken legal thinking further than it actually had. So Foucault, it's a necessary step. One can't even get off the starting blocks. I hesitate to use metaphors. There are too many metaphors in this case. But one really can't get started until Foucault has taken place and judgment been given. But there is more after that needs to be done. On the significance of Foucault, Mr. Gamy was absolutely clear. This was his paragraph 53, which is page 106 in the unagreed bundle. He identifies as one of two key elements the ECJ's decision in Foucault, and he explains that there the Court of Justice decided that Mr. Foucault was entitled to the same exemption under the Dutch tax rules for his Belgian dividends as he was for his Dutch dividends. And he goes on to say that that attracted considerable attention as indicating that domestic and foreign dividends were comparable in the hands of an individual portfolio shareholder. So undoubtedly, Foucault is a very important case. But it doesn't get taxpayers all the way to where they needed to be, and you can see why in the next sentence, where Mr. Gamy explains it. It didn't involve intercompany dividends in respect of which foreign tax credit relief was accorded for the underlying corporate tax. And it was dealing with a member state that operated a classical system of dividend tax. And what one sees after Foucault is, for example, that the judge refers to an article by Mr. David Oliver in his judgment commenting on Foucault and noting that the analysis is muted. People commenting on Foucault are wondering...
Do we have that article in the
We
Bible?
do. Yes, we do. It's at the very back of the main supplementary bundle, tab 30. The judge deals with it, first of all, at paragraph 124 in his judgment, noting that the treatment of Foucault was muted, and that Mr. Oliver had stressed that it was a judgment on tax treatment of natural persons, and he'd said, don't think, therefore, the decision in this case automatically applies to corporates. And paragraph 135, he refers to the relatively downbeat view from Mr. Oliver. And what one sees within the article is there's a summary of what Foucault decided, which occupies 329, 330, 331, 332. At the bottom of 333, Mr. Oliver looks at the implications for individuals, but what we're interested in is the implications for companies. 336. Although before I get there, I should just show you where the judge saw the passage, don't think, therefore, the decision in this case automatically applies to corporates. That's 2/3 of the way down page 333. paragraph starting, the judgment of the court seems to the writer to show some sensitivity, and then it's the third sentence within that paragraph. And then for companies, page 336, halfway down, he starts by observing, court careful expressly to limit the decision to the position of natural persons. So he says one must respect the caveat, not try to draw direct analogies from Foucault as to what might be the implications for companies, but one may speculate, he says. And then he notes a different treatment in the context of portfolio investment, so that's holdings of under 10%, which of course is not what we're interested in. We're interested in direct investment, which Mr. Oliver deals with halfway down 337. I thought as the paragraph, let us turn now to direct investment. We're not interested in foreign branches, but he then deals with investment via a foreign company halfway through that paragraph. And he notes there's relief from economic double taxation given by way of credit. And he then, in the next paragraph, says, well, there are always going to be differences. It's never going to give quite the same result. But then he observes that the court might find it approximate enough. And he says exemption for all will have to wait and see. Now, that actually is looking at the UK D5 system. What isn't even mentioned at this point is the UK FII system. So Mr. Oliver was very cautious about making any predictions at all as to the potential impact of Foucault. And he doesn't even mention the possibility of there being a read across to FII.
Well, not specifically, but it can be said at this point, Mr. Oliver is alerted to the fact that there's an argument out there.
Well, he doesn't.
Not on FII, but in general in relation to corporates, by drawing an analogy with individuals.
Yes,
That's the problem, isn't it?
having said that one has to be cautious about doing so.
Absolutely, but the test is there a case that will get off the ground?
Yes.
Not, is there a case which will win?
And my lady, just to be clear, that's in relation to D5 tax.
Yeah.
And there's no issue anymore that Foucault's enough for D5 tax. We're interested in pre-Foucault D5, and then how far after Foucault for ACT. And just for completeness, Mr. Gammy had addressed Mr. Oliver's article. It's in Appendix 2 to his report, paragraph 7 through to 11. We don't need to look at it because really he just culls the relevant paragraphs from Mr. Oliver. It starts at 162 in the unagreed bundle, but I don't need to add anything from that. What I'm going to do, if I may, under ground 4, is deal more specifically with what it was that Mr. Foucault actually discovered when it came to bringing the proceedings in the Netherlands, because that was a part of Malone & Friends' oral submissions. But before I do that, can I first deal with the first part of Malone & Friends' ground 4, which is the complaint that he says that the judge failed to consider certain cases. So I'm now on to ground 4, and if I may, I'll deal with it in 2 stages, which is the development of the law, and then look at the bringing of the proceedings in the Thakoyan case. So the 4 cases that are relied on, they were Avoir Fiscal, Daily Mail, Commerzbank, and Bachmann. There's a 2-part response, and I'll do this, if I may, by reference to each of the cases in turn, but part 1 is that the judge did refer to and appropriately consider each of those 4 cases. It's in paragraph 63 of the judgment, also in other paragraphs, and I'll show you that to make that good. But the second problem is that none of those cases would justify a date of constructive discovery that's earlier than the 6th of June 2000. And so, if I may, what I'll do is just looking at each of the 4 cases, deal with those 2 stages of my response. So case 1 is Avoir Fiscal. That's dealt with by the judge in numerous paragraphs in his judgment, and in my submission it's dealt with entirely appropriately and correctly. One can see it, for example, in paragraph 55, core bundle, page 505, where the judge notes that by July 96, this is halfway through the paragraph, there was an appreciation that even direct tax measures could contravene treaty freedoms. See, for example, Avoir Fiscal. And then there's a similar point made in paragraph 63, noting that direct tax was not an enclave to which treaty freedoms were inapplicable, citing Avoir Fiscal. Pausing there, he also says that that point's reinforced by Daily Mail and by Commerzbank. That's 2 of the other 3 cases that learned friends relied upon. And he notes another case, Halliburton, for the same point. What the judge then does is he sets out, paragraph 81, the passage from Farmer and Lyle, to which both learned friend Mr. Hewitt and learned friend Mr. Ernson have taken the court. And he notes that that's cautioning against the sort of broad approach to the Avoir Fiscal judgment that Professor Barnard had taken. And then at 91 Roman 2, the judge expressly rejects Professor Barnard's opinion that by the time of Avoir Fiscal in 1986, a well-advised multinational could, with reasonable diligence, have discovered that D5 challenges or ACT challenges were worthwhile. And as we'll see, that was based squarely and rightly on Mr. Gammy's expert evidence. And the judge also notes the cautious tone of Farmer and Lyle that he'd earlier set out in paragraph 81.
Sorry, the revving bike outside missed the paragraph that you were just referring to.
I'm so sorry, my lord. It's paragraph 91, Roman 2.
91.
It's page 514.
Thank you.
I'm very sorry. And he goes back to it again in 93. And it's a similar point, Avoir Fiscal, and it's also the Schumacher point and the commencement of proceedings in Hurst. And the judge says, I've considered these points carefully to test, in particular, whether a well-advised multinational could have done the same as Hurst in this case. And then 94, he says no, they couldn't. And in that context, he explains in particular that the House litigation that was following on closely from avoir fiscal, but as we've seen, this case is dealing actually with different and much more sophisticated points. And those findings in my submission are fully supported both by Mr. Gammy's expert evidence and also simply by an analysis of the avoir fiscal judgment. So if I can deal with Mr. Gammy's expert evidence on the subject of avoir fiscal, Unagreed Bundle, Volume 1, Tab 7, and if I can pick it up, please, first, paragraph 68, which is electronic page 110. He says at the bottom of that page that avoir fiscal had at least brought to the attention of tax practitioners that direct taxation is not the exclusive preserve of member states. And he notes how the non-discrimination principle probably wasn't actually all that surprising. But then importantly, he says this, 5 lines down on page 111, that in his experience, the avoir fiscal decision had no real impact on the general view that community law had little or no influence on the form of member states' direct tax systems in general, or on the UK's direct tax system in particular. And then continuing on, I've mentioned in paragraph 71 at the bottom of 111 the conference that Mr. Gammy describes in 71, the IFS conference. What's important for my purposes here is in paragraph 72, we're at a time, I appreciate we're quite early in the period, 1989, but there's a recognition of pressures and potential problems to which the single market would give rise. But as Mr. Gammy says, the idea that community law in the shape of the freedoms guaranteed under the Treaty of Rome could feature in any solution of those problems was, however, entirely absent, notwithstanding the ECJ's prior venture into direct
We're back to the Rudin Committee, aren't we?
Correct. Correct. And there are similar points in paragraphs 83 and 84, which this is a sort of similar episode, but at a later point in time. He's now looking in 1992, bottom of 114, top of 115, and it's reflected in the literature of the period. And then, more importantly, perhaps, paragraph 104, page 122. So he introduces the avoir fiscal decision in paragraph 103. And he says, with hindsight and the benefit of many hundreds of decisions, the idea is, he says, it's tantalizingly familiar and obvious. And he says, by 1994, there's at least the potential to influence the form of member states' direct tax systems. But the next sentence is important, because what he also says is that nevertheless, the idea that member states could no longer draw a line in their tax systems between the domestic situation and the international situation had no significant recognition among tax practitioners familiar with the international tax system. And he goes on in that context actually to deal with the passages from Farmer and Lyle that the court has already been shown. So that's after avoir fiscal, Daily Mail and Commerzbank. So that's the development of legal thinking at the time in relation to avoir fiscal. It simply did not have the effect on actual legal thinking that the revenue says it must have done or should have done. And as to the revenue's reliance on the need for an exercise where the court simply does this job for itself, avoir fiscal in any event is a very different case to the present. The Commission's challenge wasn't to the French imputation system as such. Avoir fiscal, it's not about foreign source dividends or the taxation of giving relief for income that's been taxed overseas. What it's dealing with is French branches of foreign companies are being denied a tax credit, notwithstanding that those branches are subject to French corporation tax on the same basis as French companies. So there's nothing in avoir fiscal that would suggest that there's a basis for challenging either the D5 charge or the denial of a franked investment income credit. My lady rightly mentioned Mr. Gammy going back to Ruding in his report, and it's perhaps as convenient a time as any just to show the court a couple of short passages in the executive summary of the Ruding report, picking up on the exchanges that my Lord Lord Justice Snowden had with Mr. Aronson yesterday about the recognition in the Ruding report that different tax systems and imputation systems may cause distortions, but that there's no recognition in the Ruding report that the treaty may offer a solution. So I was just going to show you briefly the material on that. It's in the main supplementary bundle. It's tab 24 of the main supplementary bundle. It's page 247. And this is published in 1992, I think, the terms of reference having been set in 1990. And this is just in the executive summary. So picking it up at page 250. The three questions that the committee says it's considered, they're all to do with distortions arising from these various differences. So are major distortions caused by differences, particularly with respect to investment decisions and competition? And two, insofar as such distortions arise, Redshaw, is action at the community level required? And then what specific measures are required at community level to remove or mitigate the distortions? And this is all in the context. Mr. Aronson emphasised this yesterday, page 249. Madame Scrivener, the member of the Commission who's setting the task, setting the mandate, she has said, paragraph 2, if such distortions do arise, it's essential to examine all possible remedial measures. And just a couple of examples. Page 252 is the summary of the conclusions and recommendations. And they say wide differences in tax regimes remain. Some of the differences distort the functioning of the internal market, both for goods and capital. Unlikely they'll be reduced significantly through independent action by member states. Accordingly, action is needed at community level. But then they note that there are other considerations in play as well. And then at 254, so this is among the recommendations which begin to be set out at the bottom of 252 and following. Some of the recommendations are intended to reduce discrimination between the tax treatment of domestic and foreign source income, and then there are various steps that are suggested. And Mr. Gammy explains in his report how in the end those steps or those recommendations don't really go anywhere. And the point, though, for our purposes is, as the Supreme Court recognised in paragraph 34 of its judgment, in this very long and detailed report, there is no mention even of the possibility that this situation might be contrary to EU law. As Mr. Gammy explains, the assumption that's made by the committee is that if this is to be dealt with, it has to be dealt with by legislative action. So I hope that's of some assistance in just picking up on the exchanges yesterday in relation to the Ruding report. Second bullet point. And I'm grateful to Mr. Ernst. I'm terribly sorry, but I think the volume's just put away the volume. But page 254, the second bullet point does specifically look at imputation taxes on the distribution of profits earned in another member state. And the recommendation is that they should be obliged on a reciprocal basis to allow such tax to be reduced by corporate income tax paid in another member state, etc. And that recommendation is to be put into effect by legislation. There's no suggestion that it's even a possibility that the treaty might already require that.
I mean, this is the executive summary. You say there's a very detailed report that backs this up.
It's over 400 pages long, my lord, yes.
Right. And what backs up this? I mean, there's a detailed analysis, is there?
It's a while since I've read the full report, my lord, but there's a very detailed analysis of the problems, particularly at a policy level and an economic level, and the impact on decision making as to capital flows, other things, of differences in member state taxes.
There's a point I was trying to make to Mr. Aronson yesterday, which I wasn't sure sort of quite how it was taken, but the more closely you look at the problem, the perhaps more significant it is that nobody actually says, hey, what about...
Indeed.
You know, the audit, I mean...
Indeed. I mean, below, as I understood the revenue's position below, they were saying, well, the Ruding Committee, they were just looking at legislative action. Why would they bother thinking about the treaty? Our position was and remains, the Ruding Committee is seeking to do a really thorough, comprehensive job. One cannot say, looking at that report, that this is not a...
Seeking to find a solution.
Indeed.
But of course, if the general mindset was it's all outside and any solution that has to come about has got to be legislation, they would only concentrate on legislation. But it actually reinforces Mr. Gammy's position, which is nobody thought that it was freedom to engage.
Exactly right, my lady. Because if they're searching for solutions, had there been an inkling that the treaty might be relevant or speed things along, one would have expected them to say so. And they don't. Now, I can't really get anywhere by turning more pages on the report, which is why we only put in the executive summary, because it's showing the court what isn't there. But what isn't there is very significant if one's assessing where legal thinking had got to by the dates with which we're concerned. So that gives a a slightly fuller picture of what's happening in relation to the Ruding report. The second decision upon which my learned friend relied was Daily Mail. And we already saw Daily Mail, that was addressed by the judge, noted by him at paragraph 63 of his judgment. Well aware that direct tax wasn't an enclave to which treaty freedoms were inapplicable. One of the cases he cites in that context is Daily Mail. And in my submission, no one could sensibly say that Daily Mail, either on its own or in combination with the cases that had been by then decided, showed that there was a real possibility that a mistake had been made that might result in FII claims or D5 claims. But the court will recall that Daily Mail, that was concerned with the United Kingdom's requirement to obtain Treasury consent to the migration of a company from the UK to an overseas jurisdiction. And that requirement, as it happens, was upheld by the Court of Justice. You'll recall, my friend took you to paragraph 16, that was at about 10 to 3 yesterday, and that was where the Court of Justice recognised that EU law can apply in relation to restrictions imposed by a member state of origin. That's what it said, it can apply. It didn't, as it happens, invalidate the UK rule in that particular case. But that proposition, it doesn't get the taxpayer anywhere in the context of cross-border dividend taxation, because it doesn't address the obvious problem, first of all, that there's a consensus that EU law doesn't have anything to say about that matter. Paragraph 51 little a of Mr. Gammy's report. It also doesn't help in establishing comparability, nor does it help in undermining coherence. And that analysis of the impact of Daily Mail, it's fully supported by Mr. Gammy's expert evidence as to the contemporaneous consensus view. He mentions Daily Mail actually many times in his report. I counted 14. I'm not going to show you all 14. I'm going to show you what I think is the most important one, and then if I may just give a couple of references of where similar points are made. In Mr. Gammy, it's his paragraph 69, so this is unagreed bundle 1. That's tab 7. And it's page 111. And he starts off by noting that Daily Mail, that was perhaps a more striking illustration, he says, of the potential reach of the Treaty of Rome into the field of direct taxation. More striking, he means, than avoir fiscal, which is what he's just dealt with in the previous paragraph. But importantly, what he then says is that the outcome of Daily Mail may have tended to reinforce the general view that community law had little or no influence on the form of member states' direct tax systems, notwithstanding the UK government's 1988 legislative measures. Those legislative measures were to do with the Treasury consent.
What's the point he's making? It's a more striking illustration of the potential reach
than avoir fiscal, because
but the outcome. Do you mean just because the UK won? I'm not sorry. I'm just not sure I'm following what he's saying there.
Well, I'm not sure I can help a great deal more in sort of trying to construe what he said, but he does say the outcome and the ECJ's decision in favour of the UK. He's seeing it as, if anything, reinforcing the point that EU law's got little influence. That's what he's saying.
But the first bit, he says it's a more striking illustration of the potential reach
yes.
of the Treaty of Rome into the field of direct taxation.
Yes, that's right.
maybe it's just me.
Got it? Well, well, if I can just perhaps carry on, you can see more clearly what he means if one goes on to paragraph 72. I mean, the point Mr. Gammy is making, he's acknowledging what the Court of Justice has said, but he's explaining what impact that had on the actual legal thinking. And the point does become clearer in my submission if you look at paragraph 72, particularly the second sentence there. He's saying that this isn't being discussed, notwithstanding that the ECJ has made these ventures into direct tax issues in Avoir Fiscal and Daily Mail.
Well, is the point he's making that although it's made clearer by Daily Mail that the Court of Justice won't shrink from applying the treaty to direct taxation in a case where they think it might have some bearing, the reality is that they're very unlikely to do so, and that is illustrated by the outcome in that case, which is although the freedoms were technically potentially engaged, in fact the court didn't interfere with domestic legislation.
I'd respectfully submit that that's a fair assessment, my lady, and one might also add that one has to look at the specific nature of the rules under consideration, because
yes.
Everybody knows that there is a thing called EU law.
Yes.
Everybody knows that there's direct effect and supremacy and there's freedom of establishment by now, but what one has to do is look at this at a more specific level. What does that mean for the particular rules under consideration? And that's the tenor of 69 and 72. It's also the tenor of 104, which we've already, I think, had a look at, but that's where he's looking more particularly about the line being drawn. This is 122. Line being drawn in their tax systems between the domestic situation and the international situation. He's saying we've had Avoir Fiscal, Daily Mail and Commerzbank. Nonetheless, the notion that member states can no longer draw a line in that regard, that's got no significant recognition. And then just to finish off, and I'm sorry, I have actually broken my promise in that I was only going to give you the references to these paragraphs, but I've taken up your time in taking you through them. But paragraph 130 and 131, that's a reiteration of the points he's already made about Daily Mail. And I think I've already shown the court the passage at the end of 131 that the suggestion that EU law required domestic and international situations to be accorded the same treatment, that would have been thought to go well beyond the scope of the ECJ's powers, etc., to undermine member state competence in direct tax. So that's Daily Mail. The third case was Commerzbank. That was also addressed explicitly by the judge.
Well, I'm wondering, Mr. Bramner, I mean, I don't want to cut you short, but do we really need to go through this exercise for every single judgment? I mean, we can read the judge's judgment, we can read Mr. Gammy's report.
Well, if the court's not going to be assisted by me showing you those passages, and I'm very happy to do it, to cut it short and go more quickly. I could simply give you the references for Commerzbank. They're in the judgment, paragraph 63 and 92, and Mr. Gammy's report, it's paragraph 104. And I'd simply add because I'm mindful of the point that Learned Friend says this is all supposed to be a function of analysis, that the analysis of Commerzbank in my submission is that there's nothing in the actual ruling in Commerzbank or in the principles that the Court of Justice set out in that case that would have offered any support either to an FII claim or to a D5 claim. The Court will remember Commerzbank, that was about the UK refusing to grant repayment supplement to the non-resident taxpayer. It has absolutely nothing to do with cross-border dividend tax. And then Bachmann, fourth case, dealt with in the judgment paragraphs 9, 89 and 91 Roman 3, expressly rejecting Professor Barnard's reliance on Bachmann in support of a constructive discovery date of
The judge says it's
1995.
actually contrary to what she says.
Exactly. He does. And Mr. Gammy's report, it's paragraphs 107 to 111. Where he explains Bachmann and the impact of it. And the judge in my submission was absolutely right that Bachmann, not only would it not have provided any support for such a challenge, it actually would have been an obstacle to such a challenge. So if I can just draw the threads together on this aspect, in my submission there's nothing in any of the cases that Learned Friend has relied on, and that's whether one looks at the case law on its own terms, or whether one looks at this through the prism of Mr. Gammy's evidence as to what actual legal thinking made of the cases. There is nothing in those cases that enables one to say that the existing case law provided objective grounds for a successful claim in FII. In particular, none of the cases concerned a situation where the member state was being asked to give up its taxing rights because tax had been paid in another jurisdiction. Indeed, before the Foucauldian judgment, there's no reason to think that EU law would have anything to say about distortions arising from the exercise of tax jurisdiction by more than one member state. And more particularly, there's no basis for thinking that EU law would require the UK to surrender taxing rights because tax had been paid in another member state. And that's in particular because comparability was lacking and nothing was available which would let one call into question the apparent cohesion of the UK system. And so the Court of Justice was quite right. It's paragraph 215 of FII CJU1. It's the passage quoted in paragraph 24 of the Supreme Court's judgment, which I think Mr. Anderson showed the Court yesterday, that until the judgments in the Foucauldian, Lentz and Marninen cases, the issue raised by the order for reference in FII had not yet been addressed as such in the case law of the Court. So that's case law, and that was what I understood to be the first aspect of Learned Friend's ground 4. The second aspect is his argument that, well, Mr. Foucauldian discovered what needed to be discovered, and that must show that these claimants exercising reasonable diligence could have discovered their mistake at the latest. I think the way he puts it is at the time either that the Dutch court decided the Foucauldian case, or perhaps earlier when Mr. Foucauldian brought his proceedings. In my submission, that argument rests on a misunderstanding both of what was being argued in the Foucauldian case and also on as to the basis of what the Dutch court decided. And you can see the beginning of the error, actually. This is paragraph 68 sub 1 in Learned Friend's appeal skeleton, because the point he makes there is that the Hague Court of Appeals judgment, that's the Gerechtshof, he says that judgment was based on avoir fiscal. And it's right that the Gerechtshof does cite avoir fiscal, but the evidence, which the judge accepted, and indeed in my submission the analysis, is that avoir fiscal doesn't provide the principles you need in order to get a D5 claim, still less an FII claim, off the ground. So just because the Dutch court cites avoir fiscal, that doesn't support the conclusion that something's been discovered that's relevant to a potential FII claim or a D5 claim. What's then said in writing, I think this is reiterated orally, is, well, Mr. Foucault identified important truths about the law. That's how Malone Friend put it in his skeleton. And orally, what he essentially said was, well, Mr. Foucault found out, therefore an English lawyer could find out. The problem with Malone Friend's argument is that what he hasn't done is identified anything that Mr. Foucault found out that suggested that a D5 claim was a possibility, still less that an ACT claim in relation to the lack of an FII credit was a possibility. So could I please start with what Mr. Foucault actually did identify? Because as we say, and this is paragraph 33 of our main skeleton in response, if one looks at the case materials in Foucault, and the court's been shown some of those by my learned friend Mr. Yu, but if one actually analyses what's going on, those case materials do not support the revenues argument that Mr. Foucault made some discovery that was relevant to the existing consensus on double taxation. Just to cut to the chase, what he discovered and the argument he ran was that there was an investment incentive which was limited to Dutch equities, and that such an investment incentive was unlawful. And what, through his lawyers, he did in the proceedings was seek to confine the debate to that narrow issue. What he wasn't doing was making any argument about requirements on the Netherlands to give credit for overseas tax. And one can start to see this within the Foucault materials. I'll try to do this quickly. The judgment of the Gerechtshof is in, I think, the unagreed supplementary bundle, and it should be volume 3, tab 25. And this is a translation of the judgment of the Hague Court of Appeal, the Gerechtshof, which the revenue provided, I think, shortly before the trial, if I remember rightly. The court will remember that the problem in Foucault arises because in the Netherlands, there's a classical system of dividend taxation, and it imposes a dividend tax. But for Dutch dividends only, there's an exemption for the first 1,000 guilders, and it's 2,000 in the case of a married couple. And if one looks at paragraph 6.3, this is the argument of the interested party, so that's Mr. Foucault. And I'll be the first to observe there's a problem with the translation in the first sentence. But if one reads 6.3 as a whole, in context, what he is saying is that the limitation of the exemption to dividends from which Dutch dividend tax has been deducted, that's to encourage investment in Dutch shares by private individuals resident here, so that's Dutch resident. The language of to prevent investment doesn't actually make any sense when you look at the paragraph as a whole, and you've got the words to encourage, which are an orphan at the end of that sentence. But when you look at the contrast that's being drawn. And that's particularly in the following sentence. It's making this group of individuals less inclined to invest in shares in foreign companies. So that's the argument that's being summarised slightly infelicitously. What is not there in any shape or form is an argument from Mr. Foucault about double taxation or about there being a need to be given credit for his overseas tax. And it's that argument which the Gerichtshof upholds, and one sees that in particular at 6.7, which Learned Friend showed you yesterday. And it's decided on the basis of discrimination. The basis of the discrimination finding is that the two types of dividend are treated the same for the purposes of Dutch income tax. That's 6.7. And then in relation to cohesion, 6.8 is of importance, because there the court emphasises that the aim of the provision is to make investing in Dutch shares attractive by granting a tax exemption. And the court says, well, this can't be regarded as a measure in which the coherence of the tax system chosen by the Netherlands is at stake. So they're not dealing with the question whether the Netherlands can be required to give a credit in respect of income which is borne tax in another jurisdiction. Now, neither that argument nor those findings have any resonance for the aspects of the UK system with which we are concerned. If one looks at D5 tax, yes, domestic dividends are exempt, and overseas dividends are taxable with credit for tax paid. But that approach complied fully, as we saw with Mr. Aronson, with the requirements of the Parent Subsidiary Directive. And as we saw in the passage in Farmer and Lyle, the requirements of the Parent Subsidiary Directive were thought to go beyond the requirements of the treaty. And the UK ACT system is even more removed from this, because on the face of it, there's no unequal treatment in that the UK imposed a single charge to ACT, and that's before one gets on to the point that under the UK system, the ACT charge is operating to fund the shareholder credit, which is, as Mr. Gammy observed, meant that on the face of it, the UK system had a logic engaging the coherence doctrine. And that emphasis on the purpose of the Dutch legislation being to provide an economic incentive, that continues both before the Dutch Supreme Court and also, at least so far as Mr. Foucault is concerned, in his written observations to the Court of Justice. And can I just show you that briefly? Tax authorities appeal to the Supreme Court. One gets a sense of the basis of that in the following tab in this bundle, tab 26. 824 has the order for reference. And again, these are all translated documents, and the translation isn't wonderful. But 836 has the tax authorities appeal against the judgment of the Court of Appeal. And it's true that they do note 837, the tax authority starts to introduce, it's sort of halfway down the page, there's a sentence after a reference in brackets. It was also intended to some extent to meet the consequence of the double taxation system on the distributed profits of companies. That's the tax authority starting to bring up the question of double taxation. And the Supreme Court makes some findings about the purpose of the Dutch exemption, and that's at paragraph 3.4 of the judgment making the reference. So that starts at 824, and 3.4 is at the bottom of 825. The exemption, they say 4 lines down, is primarily intended as a measure to improve the equity position of the business community and to stimulate private interest in Dutch shares. So that's the primary purpose of the provision they're dealing with. They also note that at a late stage in the preparation of the relevant bill, it was added that the exemption, read short, actually functions as a measure that somewhat mitigates the double taxation as it occurs in the Dutch traditional system. And then if one looks at what Mr. Verkooyen said to the European Court, I'm afraid one needs a different bundle for that. That's in the main supplementary bundle. His written observations are at tab 13 of that bundle, and they start at page 91. If the court has page 100 of the bundle within those written observations, Mr. Verkooyen's argument is that the sovereignty, this is by the second hole punch, starting furthermore, Mr. Verkooyen's argument is that sovereignty in the field of direct taxation of the Netherlands as a member state is essentially not in question at all. And the reason he gives for that is that according to the considerations that led to the dividend exemption proposal, neither the tax system nor its coherence was discussed. The dividend exemption is an economic support measure in fiscal form. And if one turns back to the bottom of page 94, Mr. Verkooyen's basing that argument on some material that he puts before the European Court of Justice about the history of the dividend exemption. And at the top of page 95, he's emphasising that it's to improve the equity position of the business community and to stimulate private interest in Dutch equities. And then by the second hole punch, it's that those considerations that meant that the dividend exemption was limited to dividends paid on shares of entities established in the Netherlands, bill accepted by the House of Representatives on this basis. And then he says the effect of the dividend exemption on the so-called double taxation was only discussed at a late stage when the bill was being discussed in the Senate. And he refers to the opinion, this is at the top of page 96, of what's described as the Prosecutor General, maybe it's the Procureur General, of the Supreme Court of the Netherlands. We don't have his opinion, but Mr. Verkooyen refers to what he had said in point 6.4, which was that he, so the Procureur General, said, I do not find that argumentation, which a side effect mentioned at a late stage should serve as a supporting motive for the regulation. And what Mr. Verkooyen then does with that if one goes on to 105, is emphasised by reference to what he set out at point 5. The paragraph starting moreover, he emphasises that the effect of the limitation of double taxation, that didn't play a role in the submission of the proposal to introduce the dividend exemption. It was only discussed at a late stage, he says, and that's relying on what he'd set out in his point 5. So his approach is very much based on the purpose of the Dutch provisions. He's saying that this is intended to provide an economic incentive for investment in Dutch shares, and it's doing so by discriminating between Dutch investment and foreign investment. He's not making any point, and in fact he and his advisors are trying to stay away, if anything, from any point about giving relief for double taxation. He's certainly not saying that Holland is somehow required by EU law to give credit for Belgian tax. So the way this is being approached, in my submission, if anything, supports the consensus that Mr. Gammy identified. It's not that Mr. Verkooyen somehow discovered something that's relevant to our case and an English lawyer should or could have done the same thing. That's not the position at all.
So, sorry, I mean,
it's a difficult exercise, my lord, I fully accept, of looking at what's being argued, but given the nature of the point that's being run by the revenue, one does have to look at what it is that Mr. Verkooyen was actually trying to do.
so where did you, I was trying to place, you went, did you take us through 103? I was trying to keep pace with you.
I don't think I particularly emphasised anything on 103. No, I'm particularly interested in page 100, 105, and 96.
But it's right that there are two passages that you haven't taken us to in this, in which it's being clearly argued that the fiscal measure which was under challenge was both contrary to freedom of establishment and freedom of capital.
My lady, that's right. But what I'm saying is one has to look at the basis upon which the challenge is being made.
Yes.
And it's not on the basis of an obligation on the Netherlands to give relief to foreign tax or to abandon its taxing rights in relation to overseas income. That's the point. We all know that freedom of establishment and free movement of capital in
the complaint is
exists.
You didn't give me an exemption on my foreign income, isn't it?
My lady,
You would have given me an exemption if it had been dividends from shares from a Dutch company. You didn't give me that exemption.
My lady, that's right, but it's by reference to the purpose of fiscal incentive intended to stimulate interest in Dutch equities. That's got no resonance at all for the UK system, and it's not engaging in any way with the points that we were canvassing, particularly yesterday, about, for example, compliance with parent subsidiary directive, if you look at the UK D5 system, and it's not making any complaint about imputation systems generally. I mean, it can't be. The Dutch system is a classical system. That's what I'm saying. One has to be very careful about identifying what it is that Mr. Verkooyen is actually doing. We all know that European law is there. That's been there since succession. We all know that freedom of establishment is there, freedom of capital there, but they have effect in the cases in which they apply. And what one is having to work out in this case is, to what extent is there a viable argument that those freedoms would invalidate the D5 charge and the ACT charge in the circumstances of this case. That's what one has to do. And what I'm saying is that nothing that Mr. Verkooyen discovered and deployed is actually of assistance or particularly relevant to this debate in the context of the UK system. And actually the significance of the Verkooyen judgment is not so much the reasoning because there isn't any real discussion of double taxation issues. The significance of the judgment is the outcome, because once one has the outcome of the Foucauldian judgment, an advisor looking at this is able to see, and one can see Mr. Oliver doing this exercise in his article, saying, well, okay, it's an individual, it's free movement of capital, that's got its own considerations, but the outcome of this is that Mr. Foucauldian would have had an exemption for his Netherlands income. The Dutch law is being invalidated because that exemption is not being applied to his foreign income. Then you have to ask, okay, where does that lead? But it's the outcome of the Foucauldian judgment, rather than anything in particular in the context of the reasoning, that is significant for the development of legal thinking. And you can see that, for example, in paragraph 53 of Mr. Gammy's report, where he very fairly, we looked at that passage earlier, acknowledged the significance of Foucauldian, but also emphasised the differences between the Foucauldian situation and the case with which we're concerned.
So,
I'm sorry, Lord.
Sorry.
now, sorry, I'm still trying to keep out. I mean, I'm just looking at trying to fit the arguments in the document you've just shown us with Foucauldian, which I haven't got open. Amongst the many files, I don't think I've got Foucauldian open somewhere.
I mean, would your lordship be assisted if I showed
the judge said that Foucauldian, the decision of the Court of Justice, dismantled the consensus that existed in the UK.
That's right, and I accept that it imposed some pretty serious dents on aspects of the consensus. It's a very important case.
Right,
no one's denying.
So
it.
I'm just trying to twig at what point that decision or the reasoning in the decision of the Court of Justice became apparent at an earlier stage in the proceedings.
So my submission is that it's only actually the outcome of the Foucauldian judgment that produces those dents on the consensus. Do also bear in mind, my lord, that
Why? Well, okay. So
the judge has made a finding that no one in the UK would have been aware of the proceedings until the judgment came out. So there is a certain amount of.
I'm not sure that's right. Actually, not sure that is quite what he says. He says the appropriate advisor would not be aware of the Netherlands proceedings in July 1996. Is he saying that nobody in the UK would have known of the reference to the European Court before that? I don't think he's saying that.
It may not go as far as that, but if one looks at the questions that are...
Domestic proceedings, I think he's talking about.
Yeah, so you're showing here, that this is the reference, this document is a reference to the European Court.
68.
Yes, the one we've just been looking at.
I'm so sorry. So in
These are submissions, aren't
these are submissions to the European Court.
Yes, the document I was showing your lordship in supplementary bundle 1 was Mr. Foucauldian's written observations. That's the document at tab 13.
Yes, that's right.
Of the supplementary bundle.
Got it. And that's
I'm sorry, my lord, if I've jumped about because I.
That's May 1998.
So that's May 1998.
Yes.
Okay.
And my point is that even at that stage, Mr. Foucauldian is not making an argument on double taxation. He's not saying the Netherlands is required to give it credit for my Belgian income.
Sorry, maybe me, and I'll just ask it and then. You accept that the decision in Foucauldian by the European Court of Justice put a big dent in the consensus?
My lord, yes, it's a very significant step.
To what extent did the decision in Foucauldian reflect these submissions that were made by Mr. Foucauldian?
Okay. So
what I'm basically saying is, was the dent apparent before the Court of Justice delivered its judgment?
Well, my lord, we're at a prior stage, in a sense, in relation to this question, because what I'm saying is that these submissions by Mr. Foucault, they are not evidence of a dent in the consensus, because what Mr. Foucault is doing is saying there is a Dutch measure that's intended to provide a fiscal incentive.
Which bit of the... I'll try it another way, and then I will shut up.
I'm sorry.
Which bit of the European Court of Justice decision do you accept is a dent in the consensus?
Oh, I see. I'm sorry, I think I understand better the question. I'm just looking to try and find...
You can see where you're about to be taken. Yeah, I mean, I'm trying to get you to...
Yes.
Show me where...
Yes,
show me the dent.
And I'm
trying to see whether there's any evidence of a similar dent in Mr. McCoy's submissions, or in fact the Advocate General's.
And I'm just prefacing my answer by saying that what we'll see when we look at the judgment is that, as a matter of generality, there isn't, either in the judgment or in the Advocate General, any specific discussion of double taxation. The dent in the consensus really comes from the outcome of the Foucaultian reference. But the easiest thing is probably to pick up Foucaultian, which is in Authorities tab 49, which is the last volume. And it starts at page 1995.
Yeah.
And in the report, court's judgment starts at 2030. And the court sets out its summary of the Dutch legislation, paragraphs 3 through to 11. And a matter that becomes of importance to the reasoning is paragraph 11, bottom of 2031. And we'll see this echoed when we get to paragraph 50. That the court sees this legislation as having a twofold objective. So they're saying it's, as I was saying, stimulating interest, which is what Mr. Foucault had emphasised. But secondly, it's also intended to compensate in some measure for double taxation. Then you get the facts, 12 to 17. Community legislation set out 18 to 23, and this is all being done under free movement of capital, which of course is not the freedom with which we're concerned, in relation to which specific considerations do arise. And then the court starts dealing with question 1. And question 1's been set out in paragraph 24. And I do say, I mean, even if someone had been reading the official journal and asking, well, okay, what pending tax cases are there? Oh, look, there's this case called Foucault, and here are 3 questions. There's nothing in these questions that would suggest that this consensus is breaking down. It's looking quite specifically at Dutch exemption, but exemption restricted to shares in Holland. Because this is all being done at a time when it's thought, well, there's this thing called the parent subsidiary directive, the credit method is okay. And then the way it's dealt with, the court reformulates the question, as it so often does in paragraph 25. It's asking then whether we've got capital movement, and it says that there is in paragraph 30. Deals with restriction in 31 and following. There's the principle 32 that member states must exercise their competence consistently with community law. the way the case is then decided is on the basis of what the purpose of the free movement of capital is. They're looking to abolish all restrictions on such movements. That's 33. And then 34, we're back to fiscal incentive. And then it's the obverse of that in 35. And then they say in 36, that's a restriction. And then they address the member states' arguments, in particular in relation to 73D1A. Which I think they haven't actually set out in their judgment. That's about being able to treat residents and non-residents differently, and the court addresses that, as we'll see. In fact, it's summarised in 38. So these are provisions particular to free movement of capital about treating residents and non-residents differently. 41 is the government's arguments that the residents and non-residents are not in the same situation. And then they say, actually, this is before the Treaty on European Union came in, so we need to look at the EEC Treaty and the directive that introduced free movement of capital, paragraph 42. And the way it's dealt with is to say, well, national provisions which are being preserved, they're not to constitute, paragraph 44, a means of arbitrary discrimination or a disguised restriction on the free movement of capital. And so what they then look at is whether the provisions are objectively justified. That's paragraph 46. And the United Kingdom takes on head-on the point 47, well, promoting the economy. That's an objective justification. And the court rejects that out of hand. Aims of a purely economic nature can't constitute an overriding reason, paragraph 48. And then 49 it's dealt with. And I'm so sorry, I'm reminded, because I've not tied this into your Lordship's question. 48, that's Mr. Foucault's argument that's being accepted. That's the point he's emphasising in his written observations, the point at 48. And then one sees at 49, it's the governments who've emphasised the need to preserve the cohesion of the Dutch tax system. And they're the ones, and this submission is reflecting the consensus that existed. They're saying, well, the exemption of dividends, that's intended to mitigate double taxation. And then 51, essentially, they're saying, well, Dutch residents, they're subject to Dutch tax. And if you've got a company established in another member state, the profits are taxed in that member state. So there's no double taxation that the Netherlands needs to deal with. And the Netherlands also ran a more general argument on loss of revenue. That's paragraph 52. And that was supported by the United Kingdom, paragraph 53. And the Dutch added to that in 54 by saying, actually, if Mr. Foucault's right, he's going essentially to get better treatment than a Dutch resident. That's basically what 54 boils down to. The court's treatment of those submissions is in paragraph 55 and following, where they're rejected. And they're looking at this purely through the lens of cohesion. And so they look at Bachmann, 57, and then they say 58, that there's no such direct link in this case. And they say the reason for that is they're two separate taxes levied on different taxpayers. They reject the loss of revenue argument at paragraph 59 because they say that can't be regarded as an overriding reason. And then they address the UK's argument at paragraph 53. So that's the point that the dividends would entirely escape Dutch tax. And their response is a very limited one. They simply say that the dividends don't systematically escape Netherlands tax. And the reason they give is that that would be the case only if you had income not exceeding the exempted 1,000 guilders or 2,000 guilders. And then 61, they deal with a point on tax advantage, and they reject that, saying that's not a permissible justification. So that's the way in which they deal with this. It's done by reference to the coherence of the Dutch system. It's very much focused on how this particular system is operating. It's not setting out general principles. Okay. But what is critical, and Mr. Gammy recognised this in his paragraph 53, which I showed the court earlier, is that the effect of the judgment is that to the extent of this small amount of income, the Dutch authorities are unable to tax the Belgian income. That is what dents the consensus, because in relation to Mr. Gammy's 51 little a...
So I thought the consensus that the judge talks about, that this case dismantled, was he talks about the consensus that he'd referred to in paragraph 71. So at 116, the judge says the significance of Verkooyen, the decision in Verkooyen, was that it dismantled the consensus referred to in paragraph 71.
Yes.
The consensus that he's talking about in paragraph 71 has a number of component parts.
Yes.
Right? And I'm trying to understand which bit of the consensus was dismantled by the decision.
Yes.
in other words, to identify the dent. And I was thinking it was to do with cohesiveness. You couldn't...
It's particularly to do with cohesiveness,
right.
That's right.
So
it is also...
So in other words, the consensus was you could rely on cohesiveness as a justification for the discriminatory treatment which had caused a problem with freedom of establishment. And that was because of the decision in Bachmann.
Yes.
I think that's paraphrasing what's said by the judge in paragraph 71, sub 3.
That's a fair paraphrase, my lord, yes.
Right. And you say that the dent that was put into that, the reason the judge says that, if I'm following it correctly, is that in paragraphs 55 through to 58, which is right, of the ECJ decision, they say that's not right. You can't rely on Bachmann in this situation.
Yes, and that would prompt thinking about how would that then apply in the context of a case like the UK.
What I'm trying to trace back is, first of all, was that dent, or that dent which the ECJ put into the cohesive view, or sorry, the consensus view, in paragraphs 56 to 58, 55 to 58. First of all, was it apparent from what the Advocate General had said in the case? If so, where? And then was it traceable back to what Mr. Verkooyen was submitting? It seemed to me there was at least some possibility, it's not a very good translation, that Mr. Verkooyen was actually making a point, that point, at page 107 of the submissions that you've referred us to, because he was making the point that this exemption doesn't contribute to coherence. So I'm just trying to understand whether this dent that you accept that the ECJ put into the consensus is traceable back before the judgment in the ECJ.
Certainly not with any ease. I mean, if one takes the Advocate General, the first Advocate General opinion, he decides that the Dutch system is valid. He does that, of course, because he's misunderstood the way the system works. But his first opinion holds that Mr. Verkooyen's claim doesn't work. And he then issues his second opinion saying, oh, actually, I've now got new information about the Dutch system and I've changed my mind. One has to be very careful about this exercise of looking at the consensus, because
it may be me that in the last 2.5 days, I'm not sure I can recall that.
Oh well, let me show you, because this is very important.
And it may be that that's me, that I've lost it in the...
In terms of what the Advocate General did.
Well,
it
may be that I've lost that in the melee of what's the last couple of days, so apologies, it's just me.
Let me try to deal with that. It'll help if I open the correct. So do you Lordship have the Verkooyen report in the Simon's tax cases?
Yep.
There are two opinions. The first is a much longer opinion starting at 1998, 24th of June 1999. There is a second opinion at 2028, given on the 14th of December 1999. And then you get the judgment in June 2000.
Right.
And in the first opinion, there is quite a lot of detail. The punchline, though, is in the first opinion, his conclusion is that the Dutch system is valid. How he gets there, you start to see in his treatment of question 1, paragraph 7, page 2001. Paragraph 8, he says, well, just because this isn't harmonised, that's not an answer. He looks at restriction from paragraph 11 and following. And this is all being done in the context of the specifics of free movement of capital.
Well, I hate to cut across you, but actually the short answer is on page 2028, paragraph 2 of the second opinion of the Advocate General, in which he explains the mistake that he made and why it led to the decision that he came up with, which was that there was no... Originally, he said there was no problem in cohesion because he misunderstood, and why he misunderstood it. And he said, in my opinion, it was a solution justified by the necessity of preserving the cohesion of the Netherlands tax system.
I'm very
then, on the basis of the information that's given by him, he's changed his mind.
Yes, that's right, lady. And so it's an analysis that is particular to the Dutch tax system.
He thought, the Advocate General thought, that at the point where the income tax of the individuals was assessed, there was no provision in the Netherlands for the deduction of the amount of the dividend tax levied at source on dividends paid by companies established in the same member state.
Yes.
So he thought there was no corresponding provision, and in fact there was one.
That's right. Yes, I'm very much obliged.
Right.
So, when it comes to Verkooyen, one has to look at all the aspects of the consensus. So there's the starting point that there's the consensus that EU law doesn't have anything to say about this. And it's quite a tricky analysis to undertake, because actually Verkooyen is about free movement of capital, and you can see the rather different way. And this is, for example, in the Advocate General's first opinion, he looks in quite a broad brush way at free movement of capital and says, well, any restriction is bad, for example. But in Verkooyen, what you have is the court interfering with, if I can put it that way, a national measure which has been held to have among its purposes the relief for economic double taxation. So that will inevitably dent the consensus that Mr. Gammy described in his 51A, in which the judge accepted in 71 little a, that EU law has nothing to say about these matters and you need community level legislation. In relation to little b and comparability, that question is not dealt with directly by the court in its reasoning. I think I'm right in saying it's also not dealt with directly by the Advocate General, because again, he also is focused on cohesion. But the outcome of the case, once the judgment is available, is going to prompt, and Mr. Gammy sort of recognises this, and you can see Mr. Oliver doing this exercise in his article. One's going to ask, what does this mean? Does this now mean that actually they might be comparable? So that's why I say there's a dent to the consensus. That's why I have no difficulty in accepting that Foucaultian is a significant case. It absolutely is. But one has to look carefully at what the reasoning is and how it is that that reasoning comes about, because where this all comes from is, if I may respectfully say so, a much more straightforward submission that Mr. Foucaultian is running, that you have a measure which had the purpose of incentivising investment in Dutch equities, and that was not permissible. What that then led to was a judgment which, when one looks at the analysis that is given, it prompts further questions, and that's exactly what one sees, for example, in Mr. Oliver's article, and that's entirely consistent with what Mr. Gammy says about the outcome of the Foucaultian judgment. What one doesn't have is anything either in the materials or in the evidence that says that the ultimate answers which lead to the claims being made could have been anticipated either prior to the judgment or prior to the Advocate General's opinion. And my Lord, just on the point about the dates between the AG opinion and the court's judgment, that there was no focus below on the difference between date of AG opinion and date of judgment.
Well, that's understandable because the tax advisor wouldn't see the Advocate General's opinion separately. Come out together, don't they? When
Not
it's
necessarily.
reported.
Well, I can't speak to what happened at that time, my lady, because this was all quite a long time ago.
Well, the Advocate General's opinion is issued in December 1999.
Yeah.
It is.
But would it be available? This question is: would it be available to a UK tax advisor until they saw it written up in December's tax cases?
One would expect it would have been, although it may not have been seen. But the reason there's no focus on it below is the difference between date of AG opinion and date of judgment. It doesn't make any difference for
Not
claimants
from the
in
point of view
GLO.
of the issues in this case, it doesn't.
No, well, or anywhere within the GLO, as I understand it,
Right.
in terms of follower cases. So it doesn't affect the in-time or otherwise of the test claimants, but also for the
Speaking for
follower.
myself, I would have thought by the time you get to the second AG's opinion, the point is quite large.
Well, it depends what one identifies as the point, because one is reading, and I'll come on to this when we look at the FCE cross appeal, and you can see what a specialist at the time made of it when you look at Mr. Oliver's article, which was really, we can't make a lot of this yet. There are questions that arise out of
I think my lady has just encapsulated my sort of attempts to drill into this. It may not make any difference, you say, the difference, but I couldn't quite understand from my thought process why the focus was on the decision of the court as opposed to the Advocate General's second opinion, because as my lady's just said, the reasoning seems writ large in the Advocate General's second opinion, and I just thought I was missing something.
Well, I'm not sure there's anything being missed, but I think it simply comes back to the point that the Advocate General's view, important of course, worthy of great respect, often followed. It's not the statement of what the court thinks. And so
No, but you've got to remember that we're not focusing on whether the argument would win.
Yeah, exactly.
We're focusing on whether or not it's a viable or worthwhile argument. And once it's been articulated as an argument or something akin to it's been articulated by the Advocate General, then irrespective of whether or not the European Court accepts it, the argument's out there.
Well, but my lady, if one goes back to Foucault, one has to be very, very careful in my submission about when one says the argument. Because what the Advocate General has identified is that there is a classical system which has an exemption for resident income and which it doesn't apply that to non-resident income. That system cannot be justified on the cohesion basis. That's what he does.
Yes.
The Advocate General, one does not see in the Advocate General's opinion anything that allows one immediately to say, there it is, there's a viable argument that the UK D5 charge breaches the treaty. Even less so can one say there's a viable argument that the ACT charge breaches the treaty. One does have to remember that when one looks at the Supreme Court test, and we saw this yesterday, is there a real possibility that a mistake's been made? Are there good grounds for thinking that there might be a claim to get the money back? So good grounds for thinking there's a mistake. And if one's looking at the preliminaries to a claim, it's having sufficient confidence that one would take those preliminary steps. And the preliminary steps are identified as including submitting a claim to the proposed defendant, taking advice and collecting evidence.
Yes, but at the end of the day, you're looking at whether or not there's a claim or a potential argument that you can put that will get a strikeout or is going to be worth running.
My lady, that's...
in the legal sense,
My
not
lady,
in the
that's-
economic sense.
That's right.
And the question is not whether this case is on all fours, the question is whether there's enough to sow the seeds in the mind of a bright lawyer like Mr. Oliver, which they plainly was, because he thought about it. He didn't think that at the end of the day it would succeed. It didn't go quite far enough, but he did think about it. And that's why the judge has fixed on Vercoyen as the date.
Well, and my lady, for D5, as was accepted below, one can see the force in it, because there is at least difference of treatment. There is an additional layer to the puzzle when it comes to ACT, where on the face of it there is not a difference of treatment. And I've made this point already, but my lady puts to me, Mr. Oliver thought of it. What Mr. Oliver was discussing is a potential challenge to D5 provisions. Yes. That's what he's talking about.
Absolutely.
He's not talking about a potential challenge to ACT provisions on the basis of no credit. He hasn't identified that. So my lady puts to me, Mr. Oliver thought about it. He thought about the possibility for D5, not for ACT.
See, when the judge is talking about dismantling the consensus, I think what he's really focusing on is the dismantling of the consensus that the short answer to all of this was internal cohesion, the Bachmann principle, or there's no comparator. And once you get over those sort of major hurdles, you're into the realm of this sort of double taxation may be susceptible to a challenge under the fundamental freedoms. And then the question is ACT so significantly different from D5 that the legal advisor would not cotton on to the fact that there's an argument about that too?
My lady, yes.
That's really what it boils down to, isn't it?
My lady was...
And you say, well, it is sufficiently different and it wouldn't have occurred. And the judge said, no, I'm going to treat it the same.
My lady, that's exactly right, if I may respectfully say so. I mean, what I've been dealing with is the point that's made against me by my friend Mr. Ewart to say, actually, this all happened before.
Yes.
And the point I'm emphasising at this stage, because I haven't quite yet got to the cross-appeal, that we're now starting to...
But anyway, you say that Vercoyen, even on its own face, doesn't really flag up the point, certainly for D5 and certainly not for ACT.
Yes. My lady, a lot of further work needs to be done. You can see the beginning of that work in the sense of legal thinking being done by someone like Mr. Oliver. But even then, there is still a long way to go. And there's no difficulty, because for D5 it doesn't matter. The FCE date, as I understand, was good enough for those that were concerned. So in front of the judge, from Mr. Anderson said after FCE, D5, time is running. And then I think the way it was put for ACT, there's a spectrum. It could be an earlier or later date, and we now have to get into why that is. And that particularly matters for Ford and for one other claimant, which is why the cross appeal matters. But the point that I'd certainly emphasise is that there is nothing either in the nature of the proceedings that Mr. FCE brought or in his argumentation that allow the conclusion to be drawn that that consensus had been determined at a point in time prior to the judgment. I mean, I can accept there's a debate about the AG, but it doesn't matter for our purposes because the difference between date of judgment, date of AG, it makes no difference in the FCE context. It is more important in the context of FCE, which in relation to Hurst. I'm so sorry if that was unclear. That I should go back half a step. The difference between the date of the FCE judgment and the date of the FCE AG opinion, as I understand it, doesn't matter to any of these claimants. The difference between the date of the Hurst AG opinion and the Hurst judgment does matter, and yes. I'm going to come back to that under the cross appeal. I'm so sorry, we'll just give me one. And just to say one other thing, I think I may have gone too far in one respect when I said this case is not concerned with free movement of capital. It is, of course, in relation to third country differends, although those had a far more long and tortured route to show there was any involvement with the treaty at all. But Mr. Ensign rightly reminds me that I shouldn't have put it in quite as absolute a way as I did, so I'm sorry about that. I wonder if that might be a convenient moment.
Yes, I think it probably is. How are we doing for time?
I'm doing okay. I'm pretty much done on my responses to the appeal. I need to add a few points in relation to the cross appeal, if I may. And I think I had agreed with Mr. Hewitt that I would run until 2:45, was how we've done it. I'm still fairly confident of achieving that, subject to the questions I have from the bench.
I will always say 2 o'clock. Thank you.
My pleasure.